Ladies and gentlemen, welcome back to the IndieZone. My name is Kathy. Today is January 7th, 2025, and a document just appeared on the court docket. It is dated January 6th, 2025. It is Judge Hippler's order sealing the defense's replies to the state's objections to FRANKS and IGG. It says here, the court having before it the stipulated motion to file defendant's replies to the state's objections to FRANKS and IGG materials under seal, and good cause appearing, now therefore it is hereby ordered that the defendant's reply to the state's objections to the defendant's amended FRANKS motion, which was filed by the defense back on November 26th, 2024, under seal, and, ladies and gentlemen, their reply to the state's objection to the defense's motion to suppress and memorandum in support regarding genetic information shall be filed under seal. And Judge Hippler cites to ICAR 32 as legal authority. So ordered. It is dated January 6th, 2025, signed by Judge Stephen J. Hippler. A couple of things about this order. First, it's directed toward two replies. The reply to the state's response objecting to the FRANKS motion, and also the defendant's reply to the state's objection in response to the motion to suppress relative to IGG information. Substantively, the way filings go is, first, you file a motion as the moving party, as Mr. Kohberger did, for example, seeking a FRANKS hearing. Second, the other side gets to respond, and what the State of Idaho did for both of these filings is file a response objecting to the FRANKS hearing and also regarding the motion to suppress relative to the IGG materials. And then finally, a reply from the initiating party. The final word, it should be limited to just responding to what the other side has responded in opposition to the order that the moving party here, the defense, is asking for. So we go again, the order and the sequence of things. Person files a motion, i.e. motion for a FRANKS hearing. The other side files their response, i.e. in opposition to the motion for a FRANKS hearing. And then finally, there is a reply from the initiating person who filed the motion. A motion, again, is an application for a court order. Relative to the motion to suppress concerning IGG being filed under seal, that matter will be entertained by Judge Hippler per his October 9th, 2024 order on January 23rd and or the 24th if necessary. We do not have yet a schedule of the sequence of the motions to suppress as of today. Regarding the FRANKS hearing, that is in no way, shape, or form a given for Mr. Kohberger. We have gone over the difficulty of even obtaining, of qualifying for a FRANKS hearing, which seeks to suppress not evidence, but seeks to strike the affidavit in support of some warrant. Now, because all matters are under seal, we don't know which warrants or warrant Mr. Kohberger is seeking to strike here. But again, in order to even qualify for a hearing, he must show 5 separate things. It is a 5-part test. It is a conjunctive test, meaning that Mr. Kohberger could bring forth evidence under seal right now, meeting the first, the second, the third, the fourth, and not the 5th prong of the FRANKS test. It's named after the U.S. Supreme Court case of FRANKS versus Delaware. Mr. Kohberger does not get a hearing. He must meet with the evidence proffered, again under seal, all 5 of the elements for this conjunctive 5-part test. Please listen to the episodes of the IndieZone where we went over in detail regarding what Mr. Kohberger needs to show. At this point, Judge Hippler's ruling whether or not to grant this FRANKS motion, grant a hearing on it, is still pending with the court. So we're going to continue to watch the docket to see if Judge Hippler finds that Mr. Kohberger has met his very high standard of evidence proffered to qualify for that FRANKS hearing. And we will report to you as soon as that order hits the docket. Until then, this is Kathy. Thank you very much for joining us here today.